While requests for admissions are useful for taking facts off of the table, and interrogatories are useful for asking who, what, where, why, how, or when questions, oftentimes you actually need physical evidence in your case, and that's where the request for production or demand for inspection comes into play. It is used by one side to ask the other side to produce and allow inspection and copying or some other form of testing of any sort of physical object. Typically this is documents, but it is not limited to documents, as any type of physical evidence in a civil case may be inspected. There is no judicial counsel form for this, and instead, just like special interrogatories, it is created on pleading paper, with each law firm or self-represented litigant oftentimes having their own preferred template for asking them. Production is typically going to be of the original document or thing, which is then inspected and copied while the opposing party observes and then takes the documents or things back after the inspection and copying. However, the requesting party may allow alternative forms of production to be provided. If you look at the template that you have in your packet, it will begin with a caption on 28-line pleading paper consisting of your name, address, and telephone number in the upper left, followed by defendant or plaintiff in pro per, depending on whether you are a plaintiff or defendant in this case. The name of the court appears on line 8, and the name of the plaintiff and the defendant needs to be filled in the caption. The case number should be replaced with your case number, and the title of the document should be changed to defendant or plaintiff, whoever you are, your names, request for production of documents or things, and then set number, starting at 1. The propounding party is, once again, you, and the responding party is the party that you wish to respond to this request. Then you begin with set number 1. If you subsequently send another set to the same party, that would be set 2, etc. If there was ever a document that should be proofread before you send it out, it is this one. This document is full of Paul Samples, Acme Inc.'s 123 Any Streets, 321 Any Other Streets, a non-existent Fred's Copy Shop in Sacramento, and a number of other things that need to be changed out before sending it out. Be sure to proofread it very carefully before you complete this document and serve it. The first line, to Plaintiff Acme Inc. and to its attorney of record, is of course changed to reflect who you are asking, and then the line below that is surprisingly important. In the template it reads, Defendant Paul Sample demands that you produce and permit inspection and copying by or on behalf of himself or herself the documents and or tangible things in the categories described below. This line is important because you must identify what you are asking the other side to do. In this case, permit inspection and copying. If you were running tests on any other type of physical evidence, you would need to describe the tests, or if you were taking photographs of a residence or other piece of property, you would indicate that as well, as it is necessary to identify in that paragraph what tests you are demanding to be done on that property. Below, where it says place and time of production, there are 3 paragraphs, each with a checkbox. These checkboxes exist only to remind you that each paragraph is an option. When you complete these forms, you should delete the 2 paragraphs that you are not using, and you should delete the checkbox. By eliminating the checkboxes and the 2 paragraphs that are not being used, you will help avoid any confusion that the other side may have when reading your documents. The first possibility is that production is to be by production of the original documents or things for inspection and copying at, and then you provide the address where you wish them to be produced. This should be a legal photocopying service or some place where you are able to make copies of the documents, typically as the opposing party or the opposing party's agent stands and watches the documents being handled. Unless you have a good photocopier at your home, it is unlikely that you will wish to use your home address for this. After you provide this location, you will provide a date and a time during regular business hours, at least 30 if served by personal service, or 35 days if served by mail in California, longer if served outside of California, days after service of this request. It then states what you are going to do, that the requesting party or requesting party's agent will inspect and copy the documents. This type of request is useful to see the original document or other object that is the evidence in the case. In some instances, for example, if the documents have tamper-resistant coatings or other things that would evidence any sort of markings, tamperings, alterations, and this is an issue in the case, it may be necessary to see the original document, as these features oftentimes do not show up in photocopies. The second possibility is that production may be satisfied by serving by mail to, and then your address, legible copies of the items or things to be produced. Oftentimes you do not need the original items, you just wish to see a copy, and this allows the other side to simply mail a copy to you. Because the asking party bears the cost of production, you may be billed for the cost of making the copies, although as a professional courtesy, frequently offices and parties in a case will typically overlook a small number of documents as the effort and energy to bill the other side exceeds the cost to make the copies. Because you are bearing the cost of production, you may also include an option for them to produce original documents for your inspection and copying, just as you would in the first paragraph, and set a date at least 30 or 35 days out, 35 if served by mail, 30 if personally served, and longer if served by mail to an address either from or to outside of California. Finally, the third possibility you have is that the inspection of the documents or things are to be at their present location, in which case you would specify the address where they are, and a date and time during regular business hours, at least 30 days, or 35 days if served by mail in California, or longer if served outside of California, for the inspection to take place. This is particularly useful if you are inspecting a large number of documents or other physical items, or the items being inspected themselves are not subject to being easily moved to your location or to another location for inspecting or copying, such as taking photographs inside of a specific residence, as it is not possible to relocate the house, or perhaps inspecting documents that are incredibly fragile so that moving them would not be permitted. Once you have done this, you are able to have a definition section. In the template, we do not have a definition section listed. However, you may have one just as you did inside of special interrogatories. Once you have completed any definitions, you would list the category of documents or things to be produced. It is understood by the court that you would probably not know every single document that you are requesting, so you are permitted to ask for categories of documents, in addition to individual documents. Each numbered item must list either a document or category of documents or things to be produced. If describing a category of document, this description should reflect how the information, document, or other item is likely going to be stored, indexed, or otherwise accessible to the other side. If not, it is possible that the opposing side may object on the ground that the request is unduly burdensome. When completing a request for production of documents, it is very important to maintain the scope of the request to avoid it being unduly burdensome or otherwise unreasonable. One time a person came through who had sent out a request for production of documents demanding that the plaintiff, a large bank that has been around since the middle of the 19th century, produce all financial records created by the plaintiff. This request, of course, requested that this bank provide all records for every account in every country for every period of time back to when it was founded in the mid-1850s. Needless to say, this request was objected to. What the person really wished to ask for is all account statements for the account alleged in the complaint sent to the defendant by the plaintiff on or after, and then a particular set of dates. By doing that, the requesting party would have limited the documents to a particular document type, a particular account, a particular set of dates, and in doing so would make the documents readily identifiable by the other side. In addition, while you are asking your questions, keep in mind that sometimes establishing the documents that the other side doesn't have or doesn't have access to may be just as important as obtaining the documents that they do have. This is because if the opposing side indicates that a document never existed, It would be prohibited from bringing this document in as a surprise document during trial, as you could ask the court, based on the previous sworn representation that the document didn't exist, to exclude the document at trial. Despite the fact that it is possible to ask for entire categories of documents, in some instances it may be advisable to ask for individual documents, as it is more difficult to successfully object to a narrow request than a broad one. Once you have completed your request, be sure to print your name and sign at the end of the template, have a copy served on the responding party, copies on any other attorneys or parties in the case, and a copy of the proof of service sent, keeping the original request for production and proof of service.